Kalonzo Musyoka. Daniel Amalemba. Accused.
Present, Your Honor.
Associate Kihara has disappeared.
Good morning, everyone. For the state, my name is Mo. Shidako is Sonia. We are ready for the reading.
So last time I requested for those authorities that were cited that that is neither of them, or neither side of the eye, actually submitted, but I was able to capture the same authorities. I think nowadays it's so easy to get those authorities. So then I'll proceed with the ruling. So Jayne, Kihara, hearing after I refer to her as a suspect, was arraigned in court on this on the 18th day of July 2025 for 10 plea on the offense of offensive conduct conducive to breach of peace under section 94, subsection 1 of the Penal Code. The particulars thereof had been successively set out that on the 8th day of July 2025 at Nairobi City, within Nairobi County, being in a public gathering, uttered was to be open court. I want to talk about Naivasha because I know those goods were transported in NYS bus in a place called Arraigned. They were dropped there. In town, they were brought in trucks in MYKE. So all these people, nobody knew them. As I condole with the bereaved and also empathize with those whose properties were destructed, I want to tell President Ruto, this is not a war. You can win unless you want to destroy this country. It is about the youth. It's about young people who you went around promising heaven. And what you are doing now is digging deep so that they go under. It will not happen. In Naivasha, they killed one, 3 in critical condition. And as my colleagues have said, police are doing anything. They didn't try to arrest the goons. They're not doing anything. They didn't try to arrest the goons. You can see in the place goons working with them. So it is not anything that is going to end. We as Kenyans are prepared to prepare our country so that you cannot. We as Kenyans are prepared to prepare our country so that you cannot be down by one single person because you think you're so powerful, yet you have the power which we give you. You cannot use the same power to destroy us and destroy the country. End of quote. I'm quoting verbatim with intent to provoke breach of peace. So I take judicial notice that the suspect is a sitting and current member of parliament representing Naivasha constituency. The suspect was represented by a battery of council who were led by Dr. Kalonzo Musyoka, Senior Counsel, Mr. Muturi, Mr. Kihara, Mr. Kiragu, Mr. Ndego Njiru, Mr. Weregi, Mr. Malemba, Mr. Nyambu, Mr. Wabugu Wabujogi, Mr. Mageto, et al. So quite a number. So the state, on the other hand, was represented by Ms. Nora, Mr. Witi JB, Ms. Sonia, and Mr. Mamani. So in its application, canvassed orally on the 18th day of July 2022, counsel for the suspect have vigorously opposed the suspect from taking plea. So that is the kernel and quintessence that this court is called upon to make a determination on. Dr. Musyoka, Senior Counsel, has urged that on the casual glance of the charge sheet, the suspect is charged with the offense of offensive conduct under section 94, subsection 1 of the Penal Code. Senior Counsel argued that this is purely political persecution and that the alleged utterances falls within the constitutional realm and orbit of freedom of expression and press, and furthermore, the particular does not disclose any offense. He poignantly supplicated that other people or politicians have said worse statements, thereby ignoring selective and or discriminating prosecution. Senior counsel was appalled by how the arrest was conducted in terms of the public resources used and the numerical force that was used against the backlog of the misdemeanor charges that now the accused has been arraigned. And therefore, he espoused that the acts by the enforcement agency were all unconstitutional. On his part, Mr. Kihara disputed the particulars of the offense as well do not disclose the ingredients and were unconstitutional. He submitted that being a member of parliament, the suspect was a mouthpiece of our constituents and which she exercised by dint of Article 33 of the Constitution. Mr. Ndegonjiru guarded this court on the enforceability of rights within the refraction of the constitutional imperative and the dictum vis-a-vis the statutory provisions and the doctrine of stare decisis. He entreated that pursuant to Section 8.1 of the Magistrates Court Act, this court is closed to the jurisdiction to hear and determine applications for redress of a denial, violation, or infringement of, or threat to, a right or fundamental freedom in the Bill of Rights. We thus urge the court to invoke Article 33 of the Constitution in delineating whether the charge sheet borders on a threat to a right or violation of fundamental principles. Further, Learned Counsel Mr. Njiru, our most stringent argument is that the statutory provisions must be symmetrical and harmonious with the Constitution by dint of Section 7 of the 6th Schedule and Article 10 of the Constitution on national values and principles of governance. He thus avowed that this court has the jurisdiction in entertaining the instant application relating to the threat, the denial or violation of the suspect rights in the contextual review of Article 33 of the Constitution on the freedom of expression as juxtaposed with the Section 94.1 of the Penal Code. He addressed further that the particulars do not disclose an offense for the suspect to comprehend to the charges she is facing. Counsel further argued on the limitation of rights and fundamental freedoms under Article 24 of the Constitution, submitting that rights or fundamental freedom cannot be limited only to the extent that the limitation is reasonable, justifiable in an open, democratic, and civilized society. Counsel also made reference to Article 19, 20, and 27 of the Constitution. On his part, Mr. Kihara extensively submitted on the composite of the offense that the suspect is facing, basically urging that the three ingredients to the offense has not been disclosed sufficiently. Concomitantly offending Article 52B of the Constitution. The Learned Counsel, Mr. Wambuku Wanjoy, iterated that the charges were not warranted since no clear offensive conduct had been identified, with the charge sheet being broad, vague, and ambiguous. He adjured that Section 94 of the Penal Code criminalizes conduct and not political opinion or opinions, and with no nexus between the words alleged uttered with the breach of peace. Conversely, on behalf of the state, Mr. Whitty vehemently opposed and backed the application. He unerringly submitted that jurisdiction is everything, reverberating the old aphorism that a court of law down its tools in respect to or matter before it. He reverberated the old aphorism that a court of law down its tools in respect of the matter before it the moment it holds the opinion that is without jurisdiction. On the jurisdictional question of Section 81 of the Magistrates Court Act, Learned Counsel argued that under Section 8.2 Subsection 2 of the said Act, this court's jurisdiction is stemmed and hamstrung to rights under Article 25A and B of the Constitution. corollary excluding Article 10, 19, 20, 27, and 33 of the Constitution. He further argued that Section 94(1) of the Penal Code is in force and applicable in collocation to Section 7 of the 6th Schedule of the Constitution. He exhorted that, pursuant to the Article 2, Article 2, Sub-Article 2 of the Constitution, this court has no powers to legislate. Learned Counsel further, Mr. Whitty, submitted that the relevant law governing the framing of charge sheets are found under Section 89, 134, 135, 136, and 137 of the Criminal Procedure Code. He argued that the charge sheet presented encapsulated the statement of offense and the particulars sufficient to be understood by the suspect. He enjoined that at this stage there is no need to prove any ingredient, each of the ingredients, since the court will be falling into a danger of conducting a mini trial. He beseeched that the ingredients ought to be established during the main trial. So he relied on two authorities, the Kuldeep Madan and another versus Director of Public Prosecution, as well as Hussein Khalid and 16 others. So decision from the foregoing, two issues arises for determination, namely, jurisdiction to enforce the Bill of Rights by the magistrate courts. Secondly, the competence of the charge sheet. So on the question of jurisdiction, I'll start off with the Supreme Court case, Supreme Court of Kenya in application number 2 of 2011 involving Samuel Kamau Macharia versus KCB and others, 2012 EKLR, which the court held, and the court, a court's jurisdiction flows from either the Constitution or legislation or both. Thus, a court can only exercise jurisdiction as conferred by the Constitution or other written law. It cannot arrogate to itself jurisdiction exceeding that which is conferred upon it by law. The court must operate within the constitutional limits. It cannot expand jurisdiction through judicial craft or innovation. End of quote. I'll also cite the famous case of owners of motor vessel, William S. versus Perfect Oil Kenya Limited, 1989, EKLR, where I'm sure all of us are familiar with this authority, so I'll not read it. So, as aptly stated by both parties, the jurisdiction of the magistrate court in dealing with the enforcement of the Bill of Rights has since been addressed by Section 8 of the Magistrates Court Act. The parameters, despite being explicitly stated under Section 8, Section 2 of the Act, has also found fortification in the Supreme Court a decision of Hussein Khalid, which I've quoted before, during above, where the Apex Court